The clock is ticking for President Uhuru Kenyatta to set up a tribunal to investigate allegations of grand corruption that have hit Supreme Court Judge Phillip Tunoi and further tainted the image of the judiciary. 12 days after the Judicial Service Commission recommended the suspension of Judge Tunoi and investigations into the allegations of pocketing 200 million shillings from Nairobi Governor Dr. Evans Kidero to uphold his election and dismiss Ferdinand Waitito's petition, the tribunal is yet to be formed.
There is no room for discussion, there is no room for discretion. It's a mandatory obligation on the president by virtue of the Constitution to form the tribunal within 14 days. That means he currently has 2 days to go.
Article 168, sub-article 5 of the Constitution requires the President to establish a tribunal to probe Judge Tunoi and suspend him for the period of the investigations. Though State House spokesman Manoa Esipisu acknowledges the President received the petition recommending the establishment of a tribunal to investigate Tunoi, he claims vital documents were missing, among them a report detailing how the Commission arrived at its decision. The Judicial Service Commission, however, insists it delivered the petition and all other necessary documents as required by the Constitution. This back and forth between State House and the judiciary further muddying the waters despite the clear constitutional timelines.
The question is simply, was a petition delivered or not? The question is not whether they are supporting documents, whether they are exhibits, whether there is evidence. It is a simple question. Was what was delivered as a document that constitutes a petition?
Should the President fail to establish a tribunal to probe Tunoi within 48 hours, he could face legal and political consequences, including an impeachment petition. The Constitution outlines grounds for the President's removal, among them gross violation of the Constitution.
The first is you can go to the High Court. The High Court has the power to deal with any question of application or enforcement of the Constitution and seek orders against the President. And I think it would be embarrassing to the President if he's made a respondent to a case in the High Court, and if the court starts discussing the question of whether he's in default, and if so, what orders of a coercive nature can be issued against him. That would be the purely legal approach.
The delay in establishing a tribunal to probe Tunoi has been attributed to the vicious succession wars in the judiciary after Chief Justice Dr. Willy Mutunga offered to retire in June. Attorney General Professor Githu Muigai is reported to be eyeing the top judiciary job and indicated he was not consulted in the current stalemate over the establishment of a tribunal to probe Tunoi.
The Office of the Attorney General advises, where the advisors sought, on whether in the totality of the circumstances there exists material to proceed with further action.
Sources indicate the 72-year-old judge was being prevailed upon to exit the judiciary and avoid facing a tribunal that could expose the rot in the highest court in the land. Tunoi, however, insists on facing the tribunal to clear his name. Francis Gashuri, Sunday Live.